So we're here to discuss what it means to see credible national trials of atrocity crimes, when that is possible, and when that is not possible, how does the ICC come in? That is the essence of complementarity. Complementarity has played a key role in every situation at the court's docket. Over the past decades or the past years, really, we've seen presentation just sort of completely disappeared, but I know it. So over the past years, we've seen important practice and case law that has tried to provide answers to how complementarity looks like in practice, shaping both the substantial aspect, but also the practical effect of this principle. And what we're seeing across the ICC situations is that the relationship between the ICC and national domestic systems is one both of partnerships and one of vigilance. So by partnerships, we refer to the active collaboration of the ICC and national judicial systems. A good example that Human Rights Watch has pointed to is in the Central African Republic and the collaboration between the ICC and the Special Criminal Court. But Human Rights Watch has also tried to put attention on vigilance, because often partnerships with national authorities won't be enough. Within our comments to the draft policy on complementarity and cooperation, Human Rights Watch had the opportunity both to share comments and to participate in a joint letter with over 40 organizations. And we try to underline this delicate balance between partnership and vigilance and the role that the office plays in complementarity. And partnership is key when there are genuine national proceedings carried out for the investigation and prosecution of atrocity crimes and Rome Statute crimes, where the office of the prosecutor plays a key role as a catalyst in encouraging national judicial measures. In our comments to the draft policy paper, Human Rights Watch also stressed that the office of the prosecutor should identify steps it plans to take in order to become this real catalyst for political will aimed at advancing credible national proceedings. And some of the steps include, again, this balancing of monitoring, partnerships, and being vigilant. So among these steps we've called for sharpening up public and private engagement with national authorities, publicly identifying benchmarks for national authorities to demonstrate they're investigating and prosecuting crimes under the Rome Statute. I know several of the organizations present here have stressed the importance of benchmarks as well. Verifying information provided by government authorities and investing in strategic alliances. And this means relying on additional sources of information. For the situation in Venezuela, this has been an issue that has been brought present by many organizations, pointing out, for example, to key findings of the UN fact-finding mission for Venezuela, or a lot of the reports that you yourselves have shared with the Office of the Prosecutor over the last years. So regular interaction is crucial for continuing to pushing things forward. And Human Rights Watch has stated that the policy of complementarity could use, for example, some bolstering in language and political encouragement to carry this out. But maybe one last point that we've emphasized, and again, this is a point that many of us have shared over the past years, is the need to increase transparency. Because this is an issue that lies at the heart of the OTP's relationships with stakeholders, including civil society. And it's crucial for this increased leverage in strategic partnerships. There has been an important opening for victims in the context of Article 18 proceedings to submit their views, but transparency needs to go further. For example, steps on or issues on transparency have been raised over the last years on what are the next steps of the investigation, what does it mean, what will the establishment of the technical office mean for the investigation and for victims' access or further access to the ICC. So more transparency will allow for the office to uphold and advance two key pillars behind its complementarity focus, which is bringing justice closer to communities, particularly communities in situation countries, and also creating a community of practice. Human Rights Watch, in our comments to the draft policy, has called on the Office of the Prosecutor to commit to more regular, public, and detailed situation-specific reporting. And this applies to all situations, including the situation in Venezuela. What has Human Rights Watch stated with relation to domestic proceedings in Venezuela regarding the principle of complementarity? Human Rights Watch has been following the current proceedings on Article 18. As you know, these are proceedings where the Venezuelan government has challenged the court's jurisdiction on the basis that it is conducting investigations. The pretrial chamber, if I can have one more minute just to finish, the pretrial chamber has ruled that those investigations do not reflect or mirror the intended investigations of the Office of the Prosecutor. This has been appealed by Venezuela, and as Faisal mentioned, we are currently awaiting the decisions of the appeals chamber. So as the investigation moves forward, I think there's questions on how does the principle of complementarity, how will it look like, not only in this coming decision, whatever the outcome, but also we're seeing how one of the questions that has been raised in other contexts is either way where the investigation or where the decision can go, how will the principle of complementarity continue to operate? So I'll leave my remarks at that. Again, thank you so much for this opportunity and very much looking forward to what my co-panelists have to say.
Thank you, Michelle. I think this is a really key issue, especially when it comes to Venezuela. We are going to face an experiment in the following months and years with the installation of the Office of the Prosecutor in Venezuela for the provision of technical assistance in terms of the light of in the light of the principle of complementarity. So I think this discussion is going to continue. Thank you, Michelle, for bringing this as the first remarkable point for this exchange of idea. And this brings me then to our next panelist. She is Catherine Valencia. She's from the Due Process of Law Foundation. And Catherine is going to have some comments about the Memorandum of Understanding subscribed by the Office of the Prosecutor with the Venezuelan state, which is really related with what Michelle was explaining first. So, Catherine, can you please tell us about what can we expect of this memorandum? What are maybe the following steps? Also, how can we kind of make some monitoring or control on the implementation of the memorandum and some other considerations you might have? Please, the floor is yours.
Sure, thank you so much, Faisal. And it's always a tough act to follow Michelle because she's someone I think so many of us look up to as an expert on the ICC and on the Venezuela investigation in particular. And I'm also very honored, of course, to be at the table with these Venezuelan human rights defenders, Bibi, Nuri, Gonzalo, and of course, Marino online. So I'm very honored and humbled to be here. Thank you. So as Faisal said, I'll discuss a little bit about the memorandum of understanding that have been subscribed between the government of Venezuela and the prosecutor's office. And I'm going to get a little bit into a technical discussion, but try to explain why these are important to the investigation, the public interest in these memoranda, and concerns about their implementation, such as how the state might take advantage to delay the process of the investigation. So to kind of recap quickly, the first memorandum was signed in November 2021 between the prosecutor and the government of Maduro. This is a public document. It affirms that the prosecutor has concluded the preliminary examination phase. So this was, concurrent to the announcement that the investigation is going to move forward. And the memorandum explains that the prosecutor has decided to open an investigation, but while also acknowledging that the government disagrees with this decision and believes that the alleged crime should be investigated at the national level. This memorandum then goes on to say that despite differences of views on this issue, the parties remain committed to actively engage with each other and support efforts further to the principle of complementarity. And then it discusses that Office of the Prosecutor, OTP, will provide support in regards to the effective administration of justice in Venezuela. So then fast forward to June 2023, the second memorandum of understanding was signed between Venezuela and OTP. This was the third visit of the prosecutor, and the memorandum was signed about 2.5 weeks before the pretrial chamber authorized ICC prosecution to resume its investigation into the situation in Venezuela. This time, OTP did not release the MOU, the second MOU from June 2023. They just put out a press release saying that the MOU confirms that discussions that were previously had, that OTP will establish an office in Venezuela. And the current understanding, as many of you know, is that this field office, OTP's field office, will open in the next couple of months. So really, you know, what we mostly have to go on then as members of the public is the press release, which establishes that OTP will provide advice and assistance to Venezuelan authorities in line with the principle of complementarity, to include assistance for legislative developments in the field of justice and sharing of knowledge and best practices with national authorities. And it also explains that OTP will work with national counterparts to basically, you know, educate them on the Rome Statute. So this is a technical field office. It is not an investigative office. It's about facilitating cooperation and engagement with authorities. And so this is in line with what OTP talks a lot about with the two-track approach of cooperation and complementarity, where so the investigation will be ongoing into Venezuela, into the situation in Venezuela, at the same time that this field office will be providing technical assistance. So I think that many in Venezuelan civil society and outside of Venezuela following the case, you know, have cautiously welcomed this office, but we have a lot of concerns as well. I think the first one, and pretty obvious, the technical assistance that OTP will provide is being provided to the same government that's being investigated by the ICC. So, you know, that's a little awkward to say the least, but one has to question how effective the technical assistance could be, even if OTP is, you know, doing a great job on their side, how will this truly be implemented? Is it really in the government's interest to adopt this kind of technical assistance and put it into practice in good faith? Another issue is that, again, as I mentioned before, this second memorandum of understanding is not public. So this raises questions about freedom of access to information. The prosecutor has made it very clear he has no intention to make this MOU public. He says it's not necessary. And the Venezuelan state has also not taken any steps to make it public, even though some of our allied civil society organizations did file a freedom of information request, but it hasn't been responded to by the state. And this isn't just a kind of theoretical concern, but the issue is, as I mentioned, the MOU talks about that OTP could provide assistance for legislative development. So that sounds like legislation, that sounds like public policies. And there is actually a pretty robust right under the Venezuelan Constitution, Article 211, which grants a right to substantive consultation with the public and civil society on legislation. So this is just a question under national law, concern there. And more broadly, it just kind of raises the point that, you know, civil society and victims, I think, sometimes feel excluded from dialogues with the prosecutor. They, you know, everyone in the public kind of found out, including victims, found out about this second MOU through the media. I think we all understand that a prosecutor's office can't be an open book. They can't be 100% transparent. Some things need to be confidential. But sharing some information about the MOU, further information about the MOU, and about what this field office is going to look like, I think would go a long way to help build confidence in the process. So moving forward, I think some of our concerns are that there should be some way for civil society to be able to contact the OTP field office to share information about how the justice system in Venezuela is actually functioning, you know, how the technical assistance is working or not working, because that would be relevant to the provision of the ongoing assistance as well as relevant to the complementarity analysis. And also this office, the opening of this office also, it raises concerns about the expectation for victims, because many people in the public might not understand that this OTP office is not an investigative office, that they're not supposed to receive testimonies of victims, it's just technical assistance. So some victims might feel, you know, false hope that this is a place they could go to receive legal assistance or provide testimony. On the other hand, just worth, of course, noting that if at some point the mandate of the office did change where it could receive victims, it would be absolutely crucial that a strong protection mechanism could be in place for anyone who would go to that office, including a mechanism for preventing reprisals. So to conclude, I think one of the concerns is that down the road is that the government quite likely might argue that that it's not necessary for the investigation to continue because complementarity can kick in here because the government's received technical assistance and it's now able to genuinely prosecute under the Rome Statute. Even if the ICC didn't buy that argument, they could still buy the government time, and that's a concern for victims who, of course, want the investigation to move forward as quickly as possible. We're concerned about, we had a discussion earlier about whether benchmarks are going to be, what are the benchmarks for success of this office, and will they ever be made public so that civil society can monitor. So I think from a civil society perspective, both as an international organization and my colleagues from Venezuela, we feel we need to know more information to be able to monitor the effectiveness of this office. So, and to kind of start to conclude and also transition to what Bibi is going to be talking about. A big concern here is that the presence of this office, the fact that Venezuela is permitting an OTP office in its national territory, it's kind of part of the show, right? That the government, where they can pretend they are cooperating with international mechanisms without really cooperating in good faith. So this is analogous, I think, to the fact that the government of Venezuela has an office of the High Commissioner for Human Rights in its territory. They're also providing technical assistance. That was mentioned by Karim Khan in this press release that, you know, there could maybe be further ICC, OHCHR cooperation, and that's all good and fine, but we know that the state of Venezuela keeps like a pretty tight leash on what OHCHR office can actually do, at the same time that they're completely rejecting the legitimacy of the Venezuela fact-finding mission, which is an extremely important international independent mechanism established by the UN Human Rights Council. Bibi's going to talk more about that. That the ICC itself has recognized the importance of the investigations that they've carried out for their own investigation, and it's deeply concerning, of course, that Venezuela completely rejects this mechanism and doesn't allow it into its territory. I know I'm over time, so I'm going to just stop here and pasar la palabra to Bibi to kind of get a little bit more into the fact-finding mission and some other issues. Thank you.
Thank you, Catherine. Just a quick reminder, if you need translation, there's interpreters available in the Zoom meeting, so just click in the link you already received. There's a channel for Spanish and there's a channel for English for the case we are speaking Spanish here. Also for the people that is in Zoom, you know that you have the option there. So thank you, Catherine, again. So Catherine already mentioned something that we are going to start discussing now. Before the Office of the Prosecutor, the ICC, started to talk about the possible commission of crimes against humanity, other international instances said it. Just to name, for example, the panel expert of the Organization of American States, but also the fact-finding mission for Venezuela. The fact-finding mission is a really important tool that might feed the investigation of the ICC, and I think is a really important point we can include also into this conversation. So for that and some other challenges we will have next year in terms of the presidential context and the election context. So sorry, we have here Beatriz Borges, Director of CEPAS. So please, Bibi, the floor is yours.
Well, thank you, Faisal, and thank you for everybody to have the possibility to have this conversation in this context, that it's not just to talk about what is happened, but it's talk about what is happening right now in Venezuela. I know it has been a long fight for justice in our case, but that has allowed us to identify some patterns, but at the same time, how the systems has evolved. In this context, to do the contextual analysis of the situation, it's important to understand the next coming years that are electoral years, and how is and why is this repression system active, and how is what is the mobile of this repression system, and how this situation and the advance of the investigation is going to be in this context. Something that I always remind, because it's the easy things, but is most obvious thing, but nobody think on this, is why the government do the human rights violation on these gross crimes. And we conclude that is because he wants to keep in the power. And that is why, in context of organization, participation, protest, election, or demand of the right, the government, the activation of the system is there. And that's why we has been alerting about the next 2 years that we have elections, and in a moment where the government doesn't have the popularity, and during the years, the different mechanism in the international arena has been monitoring what is happening in Venezuela. And one of the most important is what the investigation that we have with the ICC. And in this context, the repression that already started, we are here, and there are some detention for leaders and electoral organizations. And this is the preambulus of the year that we see, or we expect that that repression could be more violent, because the risk to lose the power is high. And this is important because this evolution that talk about what is the government doing in the international arena to participate in the dialogue space, but also showing that it's trying to cooperate with different authorities. It's not real, but it has limit to. And we are alerting the authorities and the process that what happened when that they think that the government is cooperating and government is open to participate in this very innovative policy of complementary stop. And that is important because I think the justice and we want that the things improve in Venezuela, but it has to be a real peace. And if we don't have justice, we are not gonna have possibility have this real peace. And that's why the investigation of the ICC and other mechanisms that we have in place, like the High Commissioner of Human Rights or the fact-finding mission, are complementary between each other and have different roles in terms of this seeking of justice. And also we have the way to see if there is a real cooperation of the government, because all these different mechanisms have produced recommendations, most of them in terms of institutionality and the justice system. But we see that the government said that they are advancing in that recommendation, but we as a civil society, we are doing the monitoring that they are not fulfilling the recommendation. And also there is no cooperation, for example, with the fact-finding mission. They don't allow to be in the country and have the interview. And they have this tensions with different mechanisms, with the manipulation or blackmail, that if you pressure too much, I will not cooperate. And that is important because that could happen in this NYU with the government when the investigation advance. And we have to be prepared to that situation. And we need to understand that the technical assistance does not replace the task of investigation and the ending of impunity in Venezuela. And that's why it's important to have this mechanism. And something that we are recommending and we are insisting is how to work with these different mechanisms, the Office of the High Commissioner, the fact-finding mission, and also the ICC. And we see as innovative this capacity to dialogue between the ICC and the fact-finding mission. Next year is going to be a very important moment for the renovation or for the continuum of justice and for the work that the fact-finding mission has been doing for Venezuela. And we think it's important to work since now and to think what is important for as a Venezuelan, as a justice, as a victim, to that the fact-finding mission keep doing the work that they are done, and the other topics that they need to investigate too, and how they can handle a relationship more deeper in this policy of complementarity with the fact-finding mission and the ICC in terms of seek the real justice for victims and to take advantage of all the information that the fact-finding mission has produced during the last years. And that we think that's a very important role that the fact-finding mission have to fulfill in the case of Venezuela, and in a context that the attentions about Venezuela is low. We have this different crises around the world, and Venezuela is not in the agenda. But the numbers, the deep of the crisis, this humanitarian crisis, the human mobility crisis, the human rights crisis are in numbers that are very deep and are very grave, and dependence of that show that to the world, and depend of the international community doesn't allow the impunity in Venezuela and keep Venezuela in the agenda, because it's necessary, because people and victims are being fighting so many years for this justice, and impunity in Venezuela could be a very bad message. Venezuela is the first investigation, sorry, and I will finish. Venezuela is the first investigation in the Americas, and the results, what happened with Venezuela is going to be an impact in the region about what the international community deal with impunity, and how international community don't allow to blackmail or manipulate for a state and ask for real improvement and real response for the victims and for all the gross crimes that have been passing in Venezuela and passing right now.
Thank you, Vivi, for those comments. Since we are going to face an electoral context next year, the presence of the work of the fact-finding mission is going to be vital for all of us. We have seen how the outcomes of their investigations and reports are feeding, for example, the own investigation of the Office of the Prosecutor. So having a fact-finding mission coming along and working with us is going to be really important for next year too. Gonzalo, Vivi mentioned about the fact-finding mission and some of the remarkable conclusions of the fact-finding mission lately has been that the repression apparatus, the repressive system remains in Venezuela. We can see signs, we can see some red flags on how this is still in place, even though there's this narrative of normalization that is counteracting the findings of the mission. So I would like to first start discussing about this and what are your thoughts on this particular matter. The floor is yours.
Thank you. Well, it's an honor to be here with all of you, really, and it's an honor to speak about the situation in Venezuela, considering that we are representing, or NGOs are representing a lot of direct victims of the crimes against humanity that are being committed in Venezuela, not since a few years ago. This has been taking place for a long time. This is very important to understand. The first time we began to speak about crimes about humanity in Venezuela was so far as 2004. We were talking about crimes against humanity in Venezuela. So this reveals to us that this is not a speed race. This is not something that has been improvised or, just begun now. This is something that has been taking place for a long time in our country. And the efforts of the victims are the ones responsible for the opening of an investigation. At this moment, the first investigation in the Americas, as Vivi said, about in Venezuela for the commission of crimes against humanity. That is a very important milestone in the history of the International Criminal Court, and it is something to be considered. We need to consider this as a very important milestone, as a very important threshold that we have to again continue working, because this will mean justice for the victims if the efforts continues as we are doing right now. Okay, one of the main problems we have at this moment with this situation is that we're talking about conversations between the OTP and the government of Venezuela. We are talking of memorandums of understanding. We are talking about the constitution of a technical support office of the OTP in Venezuela. But while we are discussing this, the crimes are still being committed. So this is a very atypical situation. For one side, we have a prosecutor that is investigating what is going on at this moment while we are speaking in Venezuela, but in the other hand, is talking with the government in order to perfect or to implement the ways necessary for the government of Venezuela to address these issues. So this is somehow contradictory in our view, okay? Because one of the problems we have now is that the victims do not fully understand the nature of the investigation, the extent of the investigation, and the nature of the investigation. Okay, the victims don't understand this, and they do not understand, for example, how is this that the OTP is talking to the government and not talking directly to the victims, for example. Okay, that is something that needs to be addressed. As we speak at this moment, we have now 2,075 political prisoners in Venezuela in jail at this point, okay? And besides that, we have another 14 arrest warrants that have been recently issued against people just because they belong or they militate in a party that is considered a party of the opposition. So this phenomenon of persecuting people is still going on. We have reported, for example, more than 116 cases of torture, okay, directly to the OTP office, okay? And we are now reporting more cases because the torture is an ongoing situation, okay? It's something that is happening still in Venezuela. We have more than 300 people that has been killed in the context of protest or manifestations in Venezuela since 2014 to this moment. All of these issues need to be addressed at this moment, while the OTP is talking about the positive complementarity and trying to make the government to investigate these facts, even considering that the rule of law in Venezuela has been in the last levels of the World Report. For example, the World Justice Project has labeled the rule of law in Venezuela in the last place for the last 5 years, 6 years. So it is a very complex scenario we have now. We have crimes being committed. We have the prosecutor office trying to get in collaboration with the government. The victims do not understand the dynamics, okay, between these two entities, and they do not understand, for example, why this office is only a technical or cooperative office, and why this office is not established, for example, for the protections of the victims. They do not understand, okay, and that is something we need also to address at this point. Okay, we don't know what will be the decision of the appeals chamber at this moment, but we are confident that the investigation will continue. Okay, the problem is that if we somehow show or step into the trap of the government of showing to the international community that everything in Venezuela is going well, that the judicial system in Venezuela is improving itself in order to take care of these kind of situations. That the memorandum of understanding, for example, between the prosecutor's office and the government in Venezuela is really working. Okay, if we show this to the international community, what will happen is that somehow the investigation will stall or will diminish or will disappear. And that is attractive. If that happens, that is attractive. Okay? Because there is, I want to be very clear about this at this moment. There is no possibility, not in the next year or in the next few years or now, there is no possibility for justice for the victims of crimes against humanity in Venezuela. The system is not structured to provide justice. And no matter how cosmetic changes you do to this judicial system, there is no possibility whatsoever of justice for the victims of crimes against humanity in Venezuela at this moment. So we have to keep fighting in order to controvert or to explain to the world that the situation in Venezuela is not normalizing, that the situation in Venezuela is not better, that the situation in Venezuela, even with the mission of the High Commissioner of Human Rights in the UN, even with this representation of the OTP's office in Venezuela, even with those situations, the situation in Venezuela is not better. On the contrary, it is worse because the government is very clever. The government will use these situations in order to try to prove to the international community that in Venezuela everything is okay, that these cases that we are talking about are no more than isolated cases, and there are no crimes committed in Venezuela, that they are very willing to cooperate with the international community, and that is a lie, I have to tell this very frankly. And these are the demons that we have to fight at this moment, okay? We have a lot of work to do in order to dismount this narrative of the government, in which they are trying to do the best they can in order to bring to the justice to the people that is guilty of these crimes. That is not true. That is not going to happen in the near future. And we have to be, as NGOs and as representatives of the victims and as civil society members and organizations, we have to be very conscious and very aggressive towards the international community in demonstrating what is the truth in Venezuela at this moment, because the government has this complete strategy, this propaganda that is considering, that is trying to show the international community that in Venezuela everything is okay, and that is not the case. 275 political prisoners at this moment, more than 900 cases of torture, perfectly documented only from 2014 to this date, more than 300 people killed in the context of protests, forced disappearances continuously happen in Venezuela. At this moment, while we speak, Roberto Abdul, deemed as a member of the political party of Maria Corina Machado, nobody knows where he is. He has been arrested. Nobody knows at this moment while we are speaking. Nobody knows where he is. The lawyers don't know how to contact him. His family doesn't know where he is, and this is happening. But that is one of the major challenges we have right now. While we are speaking about this, while the OTP is trying to, somehow get in touch and collaborate with the government, this is all happening. And I wanted to finish my considerations with that remark. Okay, we are talking about crimes that are being committed while we are speaking at this moment, and that makes it very difficult to deal with all the things involved in these relationships between the government, the OTP, and even international.
Thank you, Gonzalo. Gonzalo is from Foro Penal. Now I'm going to start speaking in Spanish for the introduction of our next speakers. Parte de lo que Gonzalo estaba mencionando sobre cómo en Venezuela se siguen cometiendo en este preciso momento violaciones graves de los derechos humanos que pudiesen constituir crímenes de lesa humanidad, forma parte de esta complejidad que hay en la crisis de Venezuela y cómo el ecosistema de represión y su esquema requiere atención y además una lupa bastante sofisticada a la hora de hacer los exámenes sobre lo que sucede en el país. Y una de las cosas que, por ejemplo, la Misión Internacional de Determinación de Hechos ha identificado es la existencia de grupos paralegales que operan al margen de la ley, pero que son también instrumentalizados por el Estado para la comisión de graves violaciones de derechos humanos y que además gozan de altos niveles de impunidad. Dicho esto, quisiera darle la oportunidad a Marino Alvarado de Provea para que comente un poco sobre estos temas y por qué es relevante para la investigación de Venezuela. Gracias, Marino. El espacio es tuyo.
Saludos a quienes están de manera presencial, saludos a quienes están conectados. Me toca abordar un tema que se ha discutido poco y se ha debatido poco, que tiene que ver con la participación de los grupos paramilitares en la represión a la disidencia en Venezuela. Grupos paramilitares que pueden estar muy activos en el 2024, porque la experiencia ha indicado que en periodos preelectorales el gobierno les asigna una importante responsabilidad para reprimir. Los crímenes de lesa humanidad ocurridos en Venezuela han sido perpetrados por funcionarios civiles y militares, así como por individuos a favor del gobierno actuando como miembros de las fuerzas de seguridad oculto consentimiento. Estos individuos forman parte de organizaciones paramilitares creadas o toleradas por las autoridades. Se les conoce bajo la denominación de colectivos. Los colectivos actúan como parte de la estructura orgánica represiva del gobierno nacional. Bajo el concepto de la unidad cívico-militar, como base de una política de gobierno que da mayores facultades a los militares en la gestión pública, ahí participan los colectivos. Se incorpora a estos grupos paramilitares conformados por civiles armados y se le da responsabilidad en labores de defensa de la soberanía y represión a la disidencia. Diferentes organizaciones de derechos humanos y analistas sobre la violencia en Venezuela han documentado la estrecha relación entre los grupos paramilitares y los organismos policiales y militares en la acción represiva. Como parte de la represión por motivos políticos, han realizado actividades tales como asesinatos, detenciones arbitrarias, encarcelamiento en centros clandestinos, malos tratos y tortura. Policías y militares han instruido o permitido que los colectivos usen armas de fuego y gases tóxicos contra quienes realizan protestas con contenido político o por reclamos sociales, ya sea porque reclaman servicios públicos, aumento de salario o respeto a convenciones colectivas. Es decir, los colectivos no solo han sido usados para reprimir acciones ciudadanas por motivos políticos, sino también por motivos sociales. En las investigaciones realizadas por la Misión de Determinación de Hechos de Naciones Unidas para Venezuela, estableció en su primer informe de septiembre de 2020 lo siguiente. La misión ha visto referencias a los colectivos en documentos oficiales, en particular referencias a su papel en el mantenimiento del control social en los barrios o como informante del gobierno. Ha expresado igualmente la misión. Durante las protestas políticas, los colectivos estuvieron en algunos casos involucrados en el control de multitudes o en violaciones en coordinación con la Fuerza Armada del Estado y por instrucción de dirigentes políticos del Estado. En varios casos investigados por la misión, los colectivos fueron identificados como responsables de asesinatos de manifestantes. En las investigaciones sobre las violaciones a derechos humanos en el contexto de las protestas, la Misión de Determinación de Hechos ha indicado. La misión observa que los planes y políticas de seguridad aplicados a las manifestaciones ofrecían un margen amplio para la intervención militar y paramilitar en las protestas, y en ocasiones para la participación de colectivos o grupos de ciudadanos armados en tareas de seguridad. Testimonio de un joven detenido por un grupo colectivo denominado 5 de marzo, que opera en la ciudad.
Marino, estamos teniendo un poquito de problemas al escucharte, se congela la imagen.
Días. Las nuevas autoridades impuestas desde agosto del 2017 no han dado resultado de esas investigaciones. En el proceso Venezuela I por crímenes de lesa humanidad, el documento que mejor refleja la posición del fiscal de la CPI en su solicitud del 1 de noviembre de 2022 a la Sala de Cuestiones Preliminares 1 para reasumir la investigación, el fiscal ha afirmado que hay motivos razonables para creer que por lo menos desde abril del 2017, las fuerzas de seguridad del Estado, autoridades civiles y miembros de grupos progubernamentales llamados colectivos habrían cometido encarcelamientos, tortura, violaciones, violencia sexual y persecución por motivos políticos como crímenes contra la humanidad. Más concretamente, los colectivos habrían cometido entre 300 y 400 casos de tortura en situación de detención contra opositores o personas percibidas como tales, y habrían cometido además distintas formas de violencia sexual. Para el fiscal de la CPI, los colectivos no parecen estar siendo investigados por las autoridades venezolanas, lo cual es contrario a los hallazgos de la oficina del fiscal durante el examen preliminar, que indicaron la participación de esos grupos en arrestos y malos tratos contra manifestantes y en colaboración con los cuerpos de seguridad. Además, para el fiscal, el sistema legal venezolano parece impedir que esos grupos sean investigados por tortura, limitando la acción penal solo al tipo de lesiones personales. En conclusión, la responsabilidad de los grupos paramilitares en Venezuela deberá ser esclarecida a nivel nacional o ante la CPI para que las víctimas de los llamados colectivos puedan tener derecho a conocer la verdad, a tener justicia y reparación, y para que ellas y la sociedad toda vean garantizado el principio de no repetición y el efectivo desmonte de estas leyes. Gracias y gracias a los intérpretes.
Muchísimas gracias, Marino, por tu intervención. Ciertamente, Marino denunciaba parte de lo que ha sido la materialización de cómo ha tomado lugar estas violaciones graves a derechos humanos en Venezuela. Y con esto me permito entonces abrir el espacio para nuestra próxima intervención. Con nosotros está Meudi Ocio. Meudi está en representación de la Fundación Fernando Albán, pero además Meudi es una víctima. Meudi es la viuda del concejal Fernando Albán, detenido arbitrariamente, muerto en custodia. El caso del concejal ha sido uno de los casos que mejor nos ha hecho ver lo cruel que puede llegar a ser la persecución en Venezuela, los pocos límites que tiene el aparato represor en nuestro país y cómo pueden tomar ciertos casos para que sean ejemplarizantes a los fines de inhibir, de acallar y de lograr el cometido último, que es la perpetuación en el poder, lo que el gobierno es capaz de hacer y hasta dónde puede llegar. Pues, desde el año 2015 hasta hoy se contabilizan al menos 12 detenidos por razones políticas que han muerto bajo la custodia del Estado venezolano. Y creo que por eso siempre es importante que en estos espacios permitamos que las víctimas, que familiares puedan tener una voz, que los escuchemos, porque todo esto, al final, estos esfuerzos, este trabajo, estas conversaciones técnicas y legales se resumen en un impacto positivo que queremos ver en la vida de las personas, de quienes han sufrido lo peor de estos actos de persecución y por quienes estamos trabajando para que haya justicia nacional e internacional. Así que, bueno, Meudi, muchísimas gracias, como siempre, por estar con nosotros. Siempre va a haber un espacio para ti y el resto de las víctimas para que puedan venir a conversar y expresar cómo se sienten y en este particular contexto, ya que estamos hablando pues de la investigación de la CPI, de las labores del fiscal, de lo que podemos esperar, yo quisiera empezar a escuchar, bueno, cuáles son las perspectivas que puede haber desde el lado como víctima, cómo sentirse frente a esta investigación, qué representa y qué podemos esperar y qué nos pides, qué podemos seguir haciendo nosotros como miembros de sociedad civil, representantes de distintas misiones diplomáticas, otros actores que tengan interés en la situación de Venezuela y al final de la justicia, para que sus casos, si se escuchen, sus casos reciban la verdad correspondiente, la justicia que quieren y merecen, y sobre todo la reparación y sanación que por tanto tiempo han buscado. Gracias, Meu.
Gracias. Saludos a todos y les agradezco la oportunidad de estar aquí y poder conversar con ustedes. La la expectativa que los familiares y víctimas tenemos con la Corte Interamericana de Corte Penal Internacional es de esperanza de que esa justicia llegue en algún momento. En el caso particular, a mi esposo se le violaron todos sus derechos. Fue víctima de detención arbitraria, desaparición forzada, tortura y muerte en custodia. En custodia del SEBIN, que es la Policía Política de Venezuela, en sus instalaciones con máxima seguridad. Informaron a la opinión pública y a los familiares que mi esposo se había suicidado. De eso hasta ahorita, hace ya 5 años y 2 meses, hoy precisamente se está cumpliendo un mes más, nunca han podido probarlo y nunca nos han dado el acceso para que nosotros podamos probar y saber a ciencia cierta qué le pasó a mi esposo. Tenemos información por indicios, por otras investigaciones, pero nunca dieron el acceso, más bien hubo más represalias contra los abogados, contra la familia, allanando mi oficina, mi casa. Las víctimas en Venezuela no vamos a conseguir la justicia. No tenemos esa posibilidad. Y se ha abierto esta posibilidad en la Corte Penal, en la comunidad internacional, para que podamos obtener en algún momento esa justicia que tanto se han hecho. Actualmente, como lo decía Gonzalo, se está viviendo esa injusticia en Venezuela. Casos recientes, eso no ha cambiado, ni va a cambiar mientras ese régimen esté en Venezuela. Ellos mismos no se van a investigar parcialmente lo que ellos mismos cometen o mandan a cometer a su. Eso es lo que tienen los familiares y víctimas, esa esperanza de que en algún momento la justicia nos llegará.
Muchísimas gracias, Melody,
Gracias.
por la voluntad y las ganas de estar acá, la apertura, la transparencia. Sabes que en este movimiento siempre encontrarás el apoyo que merecen y seguiremos haciendo los esfuerzos necesarios para que esa justicia que tanto buscan y por la cual han luchado incansablemente sí se materialice como se debe.
Gracias.